Welcome back. Well, in just a minute, we'll be joined by our friend Horace Cooper, great contributor to this show. The man I think is America's greatest constitutional mind and lawyer. And also, if our friend Jeff Sessions is not confirmed, and I hope he will, I think he will be, but if for any reason he's not, Horace is the man I want to advocate for the next AG, and I think Horace should be Donald Trump. You know, if Donald Trump gets 2 terms, he could end up picking as many as 5 Supreme Court justices. It's possible with the age of some of these cats on the Supreme Court. I want Horace to be one of those. Who knows, if Trump does 2 terms, he could go through 4 or 5 attorney generals. Who knows? You go through a number of them. So Horace has got to be one of those, and I will be advocating that. Well, the Ninth Circuit, the travel ban, to me, it looks like a very simple legal issue. We'll see what Horace says in a second. But people coming into this country, if they haven't yet entered America, no constitutional rights attach. So for the Ninth Circuit to say, and the trial judge before that to say that there are constitutional questions involving the 5th and 14th Amendment, I don't know how you could possibly argue that. I mean, that's leaving aside the whole issue of whether states can claim damages and have standing. Maybe that's a somewhat murkier issue. I don't think there are any damages, but admittedly, it's somewhat murkier. But this issue, I don't know how, unless they are now extending constitutional rights to not only aliens in the United States, which I think is bad enough, but that's settled law, and to now people who aren't even in the country, which is nuts, because that means that somebody in Moscow could claim that they have constitutional rights in the States. Horace Cooper, welcome to the show.
Hey, thanks for having me on.
Well, you're joining us with a cigar from your patio, but I wish you were joining us as Attorney General from the Justice Department. Maybe someday I'll get my wish.
Well, let's focus in on today's issue,
yes.
And that is, this is a good example. If people watch the arguments, they were broadcast, or at least they were simulcast. If you watch those, it's a good argument for why we want the judicial branch to be out in the public. If you had sat in a class and answered questions or asked the kinds of questions that these 3 judges did, you would have been ridiculed. Now, normally, this kind of wacky decision-making is not seen by the American people because federal courts don't allow cameras or audio in the courtroom. An exception was made in this case, and we got to see how bad this was.
It's almost like the Florida Supreme Court 17 years ago, Horace, huh?
Absolutely. And in this case, the judges decided that they weren't even going to focus in on the issues that were briefed. Here's the crux of the questions that they were trying to drill down on. Does the First Amendment's provision that there shall not be an establishment of religion mean that if the President of the United States wins election after having campaigned on what was called a Muslim ban and then enacts an order that restricts immigrants, can they use their power to then strike it down? That is not what the ACLU argued. That is not what People for the American Way or any of the Muslim front groups that Soros has been funding argue. That's not even what the briefs suggested. This took us way, way far beyond where things are. The primary problem, and there are lots, the primary problem is what you're supposed to do with a statute is look at what the statute says. I can say that I'm regulating automobiles all day long in public releases. If my regulation has nothing to do with automobiles, I'm not bound by the specifics of what rhetoric was used outside of the classroom or any public arena. And yet these guys specifically kept asking the question about the president's, as a candidate's, campaign promises. They ignored the reality that this was an interagency task force recommendation, that largely the 7 countries that had been designated came as a result of Barack Obama's efforts and the prior administration. And they also ignored the fact that when the Congress of the United States attempted to pass a bill that President Obama Obama threatened to veto, it also included these very jurisdictions. It is remarkable to me that instead of focusing on the bill at hand or the actual executive order, they decided they wanted to know, well, what was going on in his mind when he enacted it. That's failure, Constitution
all right, so
101.
I presume, given all the absurdity, I presume that the final ruling of the Ninth Circuit will be against the administration. Is that accurate?
Yes, you're right, and the reason that's right is if we had seen any kind of mainstream questioning, I would have said, nope, we're going to see that the Judge Robart's order is going to be overturned. But we didn't see any mainstream type arguments. This would set a dramatic precedent, one that ultimately has to be overturned by the Supreme Court if they were to argue that this was a First Amendment violation that impinges on the ability of the president to make a national security determination.
Now, let me ask you this, why would the First Amendment even apply if people aren't even in the country, though? Wouldn't it?
Well, it doesn't. Oh, but this is the point.
That's the issue. That's the issue.
What they're saying is we don't actually care about who these people are. We're saying that the president's action itself is something that has been brought to our attention. The only problem with that is it hasn't been brought to their attention. No one has said, the way we did with the Affordable Care Act, does the government actually have the power to compel you to do X? The case is not, does a president have a power to issue an executive order?
So you have no aggrieved plaintiff. In other words, this is now in the abstract. There's no aggrieved plaintiff.
Absolutely in the abstract.
This is an abstract violation of the First Amendment. There is no plaintiff. They're issuing it's an advisory ruling. It's a theoretical advisory ruling, basically.
The Constitution precludes that. It says that we're not supposed to. You actually have to have a case, an actual dispute. Now, I've been to Washington State. Many other people are lovely. They haven't identified a particular injury or harm. The executive order doesn't require the state of Washington to expend a single dollar. It doesn't require the individuals who work for the state to be forced into some action. The court has been clear that the federal government may not do those things. This simply says, hey, we're not going to let's pretend.
Let me ask you, I got one other question in the time remaining. Could Trump take the argument, refresh me on con law, Horace, can the Ninth Circuit, the Ninth Circuit makes a ruling, does that necessarily extend beyond its jurisdiction? Is it precedent or custom that you would follow it beyond its jurisdiction?
So it's custom that it would follow, but the initial stay was written to be a nationwide stay. So the stay would have the effect of barring everywhere. The Ninth Circuit would only be able to create a precedent in this place. But Japanese steel, during the Reagan administration, there was a temporary ban as we negotiated. The Ninth Circuit was essentially saying that it would be okay for Washington State to say,
Horace Cooper, we gotta go. I am so sorry. Horace Cooper, thank you so much. If we are very, very lucky, we'll have you back again. My next candidate for AG or the Supreme Court, Horace Cooper. We'll see you next week.